Something extraordinary just happened, and almost nobody fully understands how big this really is. We are talking about a unanimous decision that dropped out of the Fifth Circuit immediately following one of the most shocking legal pivots in the modern history of federal firearms regulation. The Department of Justice, under the Trump administration, just admitted something that fundamentally undermines the legal foundation of suppressor restrictions. And then, almost as quickly as they made that admission, they started pushing back. What followed is a unanimous court ruling that has sent shockwaves through the legal system. And it has set the stage for a constitutional showdown at the Supreme Court that could determine whether the National Firearms Act survives or collapses entirely. This is not just another court ruling. This is a direct collision between federal agency power, constitutional protections, and the future of one of the most restrictive firearms laws ever enacted in American history. And to understand why this matters so much, you first need to understand the man at the center of it, and what the government just admitted about your rights. The case is United States versus Peterson. George Peterson is a Louisiana gun shop owner whose home was raided by the ATF back in 2022. Among the items they found was a single unregistered suppressor, what the ATF classified as a solvent trap being treated as a silencer. Peterson was charged under the National Firearms Act for possession of an unregistered silencer. He did not just roll over. He challenged the constitutionality of the NFA itself, arguing that under the Supreme Court's landmark Bruen decision, the government has no historical tradition of banning or even requiring registration of these types of safety devices. Now, for context, the National Firearms Act has been federal law since 1934. It imposed taxes, registration requirements, fingerprinting, and lengthy approval processes specifically designed to discourage civilian ownership of certain items, including suppressors. For decades, courts largely accepted these restrictions without serious constitutional pushback. The government's default position was simple. Suppressors are not arms, they are accessories, and therefore citizens have zero Second Amendment protections when it comes to owning one. That argument is now dead. While Peterson's case was working its way through the system, the political landscape shifted dramatically. The Trump administration came in, and with it came the passage of legislation that effectively slashed the NFA tax stamp for suppressors, short-barreled rifles, and short-barreled shotguns from $200 down to $0. This was already a massive win for gun owners, but it quietly created a legal earthquake underneath the entire NFA framework. If the tax is now $0, is the NFA still functioning as a tax law? Or has it now become a pure registration and surveillance scheme with no revenue justification whatsoever? That question alone is enough to make constitutional lawyers lose sleep. But then came the real bombshell. In a supplemental brief filed with the Fifth Circuit, the Trump Department of Justice did something unprecedented. They conceded, officially on the record, that suppressors are protected arms under the Second Amendment. Let that sink in for a moment. For nearly a century, the federal government fought tooth and nail to argue that silencers were dangerous and unusual accessories outside the scope of constitutional protection. That entire argument was thrown out the window in a single brief. By admitting that suppressors are arms, the DOJ essentially handed the constitutional challenge a loaded weapon. But here's where it gets complicated, and where the DOJ's position becomes almost impossible to defend logically. Even though the DOJ admitted that suppressors are constitutionally protected arms, they did not stop defending the NFA's regulatory structure. Instead, they told the Fifth Circuit that the registration requirements, fingerprinting, background checks, and waiting periods are still constitutional. Their argument? They claim the NFA now operates as a shall-issue permit scheme, similar to the objective concealed carry licensing systems that Justice Kavanaugh referenced in his concurring opinion in the Bruen decision. Essentially, the federal government is saying, yes, you have a constitutional right to own this arm, but we can still require you to register it with the federal government, submit your fingerprints, wait months for bureaucratic approval, and maintain your name on a federal registry, as long as we do not say no to everyone. That is the legal trap the DOJ has set, and it is an extraordinarily dangerous one. The Fifth Circuit, after withdrawing their previous opinion that suppressors were not arms at all, issued a new unanimous ruling, and it stunned Second Amendment scholars across the country. The court agreed with the DOJ that suppressors are protected arms. That much was a victory, but they upheld the NFA anyway by adopting the government's shall-issue logic. The panel ruled that because the ATF will eventually issue you a stamp, now at no cost, the regulatory burden on your rights is not unconstitutional. Think about what that reasoning actually means. It suggests that as long as the government does not ban something outright, they can create any number of bureaucratic hurdles they want. They can make you wait 6 months. They can fingerprint you. They can register you in a federal database. They can track what you own. And as long as they do not technically say no, the burden on your fundamental constitutional right is deemed acceptable. They are treating your Second Amendment right to a protected arm the same way a state treats a driver's license application. This is not just wrong. It is constitutionally catastrophic if it stands. And the court knew exactly what it was doing. By reissuing their opinion this way, the Fifth Circuit was attempting to build a legal safe harbor for gun control, a doctrinal framework that would allow the government to sidestep Bruen's strict historical test entirely by relabeling restrictions as objective licensing systems. If this logic holds, the implications go far beyond suppressors. Imagine a future where the government says, "We are not banning AR-15s, we are simply requiring an objective rifle permit. You apply, you pay a fee, you wait, and you enter a registry. We will not say no to everyone, so it is shall issue. It is constitutional. That is the door the Fifth Circuit just kicked wide open." Now here's where the story takes a turn from legal theory into a very human, very urgent crisis. George Peterson is a real person facing real prison time. After the Fifth Circuit issued its ruling, Peterson's legal team immediately sought what is called a stay of the mandate, essentially asking the court to hit the pause button on the ruling while they prepare their appeal to the Supreme Court. This is standard practice in cases of major constitutional significance. And remarkably, even the Trump DOJ, under Attorney General Pam Bondi, did not oppose the stay. The government itself was not pushing to throw this man in prison right now. But the Fifth Circuit panel denied it anyway. One sentence. Denied. They were fully aware that Peterson intended to take this to the Supreme Court. They were fully aware that the DOJ was not demanding immediate incarceration. They denied it regardless, which would have forced Peterson to report to federal prison immediately, to begin serving a 24-month sentence, for a victimless paperwork violation involving an item that the Department of Justice itself now admits is constitutionally protected. Fortunately, the district court stepped in and showed a rare flash of common sense. After the Fifth Circuit's cold and abrupt denial, the district court allowed Peterson to remain out on bond while his team prepares a petition for certiorari to the Supreme Court. George Peterson is a free man today, but only barely. He is free by the grace of a lower court judge who recognized the absolute absurdity of sending a man to prison, while the very law he is accused of violating is under active review, heading toward the highest court in the land. But the clock is ticking. The deadline for filing that petition is March 9th. This brings us back to the core constitutional question that the Supreme Court may soon be forced to answer directly. The Bruen decision already reshaped the entire framework for evaluating Second Amendment challenges. Justice Thomas, writing for the majority, rejected the interest balancing tests that lower courts had used for decades and replaced them with a strict historical standard. Under Bruen, the government cannot justify a firearms restriction by pointing to public safety benefits or policy goals. They must prove that the restriction is consistent with the historical tradition of firearm regulation in America at the time of the founding. That is an extraordinarily difficult burden to meet when it comes to suppressors. Suppressors were not invented until the early 20th century. There are no analogues from 1791. There is no founding-era tradition of the government requiring citizens to register their arms, pay a tax for permission to exercise a constitutional right, submit fingerprints, and wait months for bureaucratic approval before they could own a protected arm. The NFA is a creation of Prohibition-era panic. It was born in 1934, not 1791, and under the historical test that Bruen established, that origin is a massive constitutional problem for the government. The DOJ knows this. That is precisely why their position is so internally contradictory. On one hand, they have conceded that suppressors are protected arms under the Second Amendment, which means Bruen's historical test must apply to any regulation of them. On the other hand, they are defending a regulatory framework that has absolutely no historical precedent from the founding era. They cannot satisfy the very test they triggered by making their own admission, and the courts are increasingly refusing to look the other way. What makes the Peterson case so uniquely powerful compared to any previous NFA challenge is this unprecedented DOJ admission. In every prior suppressor case, the government's first line of defense was that suppressors are not protected arms at all. That argument absorbed all the oxygen in the room. Courts never had to reach the deeper question. Now that line of defense is permanently gone. The Trump DOJ has officially and irrevocably conceded it. Every future court that hears a suppressor case, including the Supreme Court, will be starting from the premise that suppressors are constitutionally protected arms that must satisfy Bruen's historical test. That changes everything about the legal battlefield. The Supreme Court now faces a decision that goes far beyond George Peterson and his solvent trap in Louisiana. If the court grants certiorari and takes this case, they will be forced to answer foundational constitutional questions about the limits of federal regulatory power over protected arms. Can the government impose a federal registration scheme on a constitutionally protected arm? Can they require fingerprinting, background checks, and months-long waiting periods as a condition of exercising a Second Amendment right? Can they maintain a federal database of citizens who own specific arms? And can they call all of this constitutional simply by labeling it shall issue? If the court answers no, if they determine that the NFA suppressor framework fails Bruen's historical test, the consequences will extend far beyond suppressors. The legal reasoning would call into question the entire structure of the National Firearms Act. It would impact every other NFA-regulated item. It would redefine how courts evaluate federal firearms restrictions going forward for generations. And it would make unmistakably clear that the Second Amendment is not a second-class right that can be buried under federal paperwork and bureaucratic waiting rooms. If the court answers yes, if they allow the Fifth Circuit's shall-issue theory to stand, the blueprint for future gun control becomes terrifyingly clear. Every future restriction will simply be repackaged as an objective licensing scheme. The fee can be raised, the wait time can be extended to years, the registry can expand to cover every firearm category, and the government will be able to point to the Peterson precedent and say, we are not banning anything, we are just regulating it through an objective process. That is the stakes. That is what hangs in the balance of a March 9th filing deadline in a case about one gun shop owner in Louisiana. What we are witnessing right now is one of the most important constitutional moments in the modern history of the Second Amendment. A federal court issued a unanimous ruling. The Department of Justice reversed its position and then tried to walk a legal tightrope between acknowledging constitutional protection and defending unconstitutional restriction. A man nearly went to prison for a paperwork violation involving something his own government admits he has a right to own. And the Supreme Court of the United States is being positioned to deliver a ruling that could reshape federal law for decades. The National Firearms Act has operated for nearly 90 years with relatively little serious judicial resistance. That era may be ending. The constitutional pressure coming from Bruen, from the DOJ's own admission, from the Fifth Circuit's ruling, and from cases like Peterson's is unlike anything the NFA has ever faced. The courts are no longer automatically deferring to federal regulatory authority. They are applying the Constitution as written. They are demanding historical justification for modern restrictions. And the government is struggling to provide it. George Peterson is free today. But the fight is not over. The petition must be filed. The court must decide whether to act. And if they do, the outcome will not just determine one man's future. It will determine whether the federal government retains the power to register, track, tax, and create bureaucratic barriers around arms that the Constitution explicitly protects. The unanimous decision that dropped out of the Fifth Circuit was not the end of this battle. It was the ignition point for the next phase, the most consequential phase this fight has ever entered. Everything that happens between now and whenever the Supreme Court rules will matter. Every filing, every brief, every decision about whether to grant certiorari. We are watching history unfold in real time, and the future of the National Firearms Act may never have been more uncertain than it is right now. Let's also talk about Footnote 9 in the Bruen decision, because this is where the DOJ is planting its flag, and it is important to understand just how shaky that ground actually is. In his majority opinion, Justice Thomas dropped a footnote acknowledging that shall-issue concealed carry licensing regimes are generally constitutional because they rely on objective criteria and do not give officials discretion to deny rights arbitrarily. The DOJ has now taken that footnote, a brief aside about carrying firearms in public, and tried to stretch it into a blanket justification for requiring a federal license to own a category of protected arm inside your own home. That is an enormous and legally dubious leap. Footnote 9 was written in the context of public carry. It was not a green light for the federal government to build a nationwide registry of suppressor owners, fingerprint citizens, and put them through a months-long bureaucratic obstacle course just to exercise a right that the Constitution says shall not be infringed. The Fifth Circuit adopted this expanded reading anyway. Whether the Supreme Court agrees is the question that will define this entire era of Second Amendment jurisprudence. There is something else worth addressing directly, because it comes up every time this topic enters the mainstream. The idea that suppressors are some kind of niche, exotic item that only a fringe group of enthusiasts cares about. That framing is both factually wrong and constitutionally irrelevant. Suppressors are hearing protection devices. They reduce the report of a gunshot to levels that are still dangerously loud. We are not talking about the silenced pistols you see in Hollywood films. We are talking about a safety device that protects hunters, competitive shooters, and responsible gun owners from long-term hearing damage. In countries across Europe, suppressors are encouraged or even required out of consideration for hearing health and noise pollution in communities near shooting ranges. The notion that there is something inherently sinister about a hearing protection device, sinister enough to require federal registration and fingerprinting, has always been a regulatory fiction designed to discourage ownership through inconvenience and stigma rather than any legitimate safety rationale. And now, even the Department of Justice has implicitly acknowledged that fiction by conceding that suppressors are constitutionally protected arms. We also cannot ignore the broader political and institutional dynamics at play here. The DOJ under the Trump administration made this admission, and yet DOJ lawyers are still defending the NFA in court. This is what people mean when they talk about bureaucratic inertia. The institutional machinery of federal regulatory agencies does not simply reverse course because the political appointees at the top change their minds. Career lawyers inside the DOJ have spent years arguing that the NFA is constitutional. Even when the political leadership shifts direction, the institutional reflex is to protect the existing legal framework. This is why you see the seemingly contradictory position of an administration that claims to support Second Amendment rights simultaneously defending a 90-year-old regulatory scheme that those same rights advocates have called unconstitutional for decades. That tension is itself part of what makes Peterson such a critical case, because it forces the legal system to reckon with the contradiction directly. You cannot simultaneously tell a federal court that suppressors are constitutionally protected arms and that the government's regulatory restrictions on those same arms are perfectly constitutional, without the court eventually having to choose which principle actually governs. The Fifth Circuit tried to thread that needle by inventing the shall-issue framework. The Supreme Court will now have the opportunity to either validate that approach or reject it entirely. And if the Supreme Court rejects it, if they determine that Bruen's historical test cannot be satisfied by the NFA's suppressor framework, the ripple effects will be immediate and profound. There are already other cases working their way through the federal courts challenging other provisions of the NFA, challenging other categories of restricted items, challenging state and federal regulations that have never faced the rigorous historical scrutiny that Bruen now demands. A decisive ruling in Peterson's favor would not just clear the path for suppressor ownership. It would send a signal to every lower court in the country that the historical test is real, it is serious, and it must be applied without deference to century-old regulatory frameworks that have no founding-era roots. That is the true significance of what is unfolding right now. This is not a story about one man and one solvent trap in Louisiana. This is a story about whether the federal government, having been told by its own highest court that it must justify its firearms regulations by reference to American history and tradition, is actually going to be held to that standard, or whether courts will allow the government to find procedural escape hatches that render Bruen effectively meaningless. The stakes for every gun owner in America could not be higher, and the moment of decision is closer than anyone expected.